In Marbury and Madison, the US Supreme Court established its power to strike down unconstitutional statutes passed by Congress. In 1921, Congress passed the Maternity Act, whose purpose was to appropriate funds for states who agreed to work with the federal government on projects to reduce mortality and improve health among infants and mothers. A fairly uncontroversial purpose, you'd think. Massachusetts considered that this infringed on state responsibilities for the welfare of mothers and children, so they challenged the statute. Simultaneously, a woman named Frothingham sued in Washington, D.C., claiming injury as a taxpayer whose taxes were to be spent by the federal government for the purpose of infringing on state rights. The Supreme Court found that neither Massachusetts nor Frothingham had standing to sue. Massachusetts lacked standing because the federal law didn't actually compel or restrict the states at all. The states got a choice whether to participate in the program. The court found the state was attempting to use the court to resolve a fundamentally political dispute. The court said, "We are called upon to adjudicate not rights of personal property, not rights of dominion over physical domain, not quasi-sovereign rights actually invaded or threatened, but abstract questions of political power, of sovereignty, of government." They found they had no power to do so. In relation to Frothingham, they found that the interest of a single taxpayer was so small that it need not be considered, or else every taxpayer could potentially use the Supreme Court to challenge every statute that they didn't like. The court said, "The administration of any statute likely to produce additional taxation to be imposed upon a vast number of taxpayers is essentially a matter of public and not of individual concern. If one taxpayer may champion and litigate such a cause, then every other taxpayer may do the same, not only in respect of the statute here under review, but also in respect of every other appropriation act and statute whose administration requires the outlay of public money and whose validity may be questioned." From this case we learn that to challenge a federal statute, a party must show that their rights have been infringed or imminently will be infringed by the statute. Short of this, they do not have an injury for the court to redress or a right for the court to protect, and so the court lacks jurisdiction.